All rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for argument in the matter of Washburn versus the Arizona Department of Economic Security. Et al. Our UB number 18-0116. Each side will have 20 minutes within which to present their arguments here this morning. Appellant may reserve some portion of that for rebuttal, but it's up to you to keep track of your time in that regard. We have read the briefs. We've been through the record. We've conferenced the case, so we're familiar with the issues identified by the parties and as identified by our supplemental order in this matter. We are recording the proceedings, both by audio and video, and so when you approach the podium, we would appreciate it if you would identify yourself and your client for purposes of our record. With that, appellant may proceed.
May it please the Court, Jared Sutton with Louis Roca on behalf of the appellant Aubrey Washburn. I want to start with the Court's recent order questioning whether the notice of termination that the division provided to Aubrey was sufficient and whether Aubrey waived any argument that she had that the notice was insufficient. The short answer to the Court's questions are that the notice was insufficient and that Aubrey did not waive her argument in that respect. There was no waiver in large part because the notice issue is intrinsically intertwined with the burden of proof issues that the Court asked us to brief at the outset of these proceedings. And more specifically, the division continued to bear the burden of proof during the administrative proceedings because it didn't provide adequate predetermination notice to Aubrey. Now, before we really get into the weeds here, I think it's important to keep in mind that we're dealing with two separate types of notice here. The first is the notice of termination that Aubrey received on May 1st, 2017. And that's not the first chronologically, but it's the first dealt with in the regulations. The second is a notice of redetermination or reevaluation, which Aubrey never received. Now, the governing regulation is R6 6-504. That's the regulation that was in place at the time. It's since been amended and renumbered, but that's the one that was applicable at the time. And that interprets ARS 36-565. With respect to the notice of termination, the first type of notice, both the regulation and the statute set up a very simple three-prong procedural test. The notice has to be in writing, it has to be sent 30 days before the termination becomes effective, and it has to advise the client of their right to administrative review. On its face, the May 1st, 2017 notice that the division provided actually satisfied all of those three procedural requirements. But critically, the regulation requires the division to make a substantive determination before that notice is ever issued. Specifically, the regulations provide that the division can't issue a notice of termination until, and I quote, it determines that the client no longer meets the conditions of eligibility for service. Now, that is a substantive question. That requires the division to look at evidence and make findings of fact and then apply those findings of fact to the criteria for eligibility. So this is where the notice and the connection between the burden and notice come into play. By its language, the division had to do something, right? It had to make this determination.
And the notice says it reviewed its records in doing that, right?
Correct.
And that's how it came to that conclusion.
Correct.
Do we know what those records are?
Your Honor, we can infer from the absence of records in the administrative record as a whole that there was no records. The only records that, no relevant records, I should say. The only records that the division's expert said she reviewed during the administrative proceeding was therapy notes and the like that she deemed irrelevant. It was only after the notice of termination was issued that Aubrey's mother submitted a report from the Gilbert School District, which again, the division's clinical psychologist said really wasn't all of that relevant to the determination.
If the sole question here, let me ask you a hypothetical,
Okay.
because that's not the issue here, is whether the records that were reviewed supported a conclusion. How would we test that if there are no records
Well,
in the record that we have been given to review?
I think that goes back to the burden of proof issue and what the division is required to do. I mean, if the division is required under the regulation to make a determination, it has to make that determination on some sort of evidence. And here, it didn't have any evidence because, and this is the critical part where notice and burden interplay, it didn't give a predetermination notice to Aubrey telling her, we're going to do a redetermination. That's what the regulation, when it says the agency needs to do a determination, requires. It can't be the case that the division can just pick up the record or the client's file at any time it chooses after the alleged triggering event and without notice to the client says, I'm going to look at what's in here now and figure out whether you meet the criteria for eligibility. That would be inconsistent with the nature of a determination, first of all, but it would also be inconsistent with the statutory and regulatory framework. If you look at ARS 36-55101P, it says, on admission for developmental disability services, each client and the client's parent or guardian, if any, shall be given written notice, if possible, and oral notice in their primary language in a manner which can be easily understood of the rights included in this chapter, including the right to administrative review. Now, that's a long way of saying, that's a long way of the legislature telling DES, we want your clients to know what's going on in this process. We want them to have an understanding of what their rights are under this system of developmental disability benefits that we've created. And DES understood that full well because DES adopted R6-6-601, which says the case manager assigned to a developmental disabilities client must, and I quote, assist the client and the client's family in all aspects of the developmental disability services or disabilities service delivery system. And that includes specifically the pursuit of evaluations and assessments necessary to substantiate the need for services. That's what we're dealing with here, is an assessment of the need for services. This regulation is DES telling the division, this is a complicated process. This is a process that's going to require lots of different medical specialties and lots of different tests, and there are specific criteria that have to be met. Your clients need professional help in navigating this process because they're not going to know on their own how to go about proving their eligibility for services. And what this regulation shows is that DES didn't want the division blindsiding a client with a review when the client doesn't know exactly what it is that they're supposed to be proving to the division. And this case proves why this ties back to the requirement that the division make a determination. Aubrey's mother.
So let me interrupt for just a moment. So we have, at some point, the parent obtaining a diagnosis that the child is autistic, correct?
Yes, Your Honor.
All right. And so then the piece where we have an issue is with the ability to establish that she has the functional limitations, at least three functional limitations relating to the autism diagnosis. Correct?
Yes, Your Honor. That's
okay.
correct.
So when does mother get notice? What's the first time she gets notice that the deficiency here is the inability to establish the functional limitations?
arguably in the administrative review of the initial termination, but definitely at the administrative hearing. If you read, it's not entirely clear, but if you read the transcript of the administrative hearing, it suggests pretty strongly that Aubrey's mother had no idea what specific criteria she had to meet. And she even had a colloquy with the division's expert where the expert was telling her which tests she needed to look at and how she could go about proving this. I mean, that's a critical fact here. The
So do you
division's
consider that adequate notice?
it wasn't adequate notice because the notice of termination gave Aubrey 30 days to come forward with evidence.
Evidence
before
of what? Evidence of what, though?
Evidence to prove her eligibility to continue receiving services.
Was it that, or was it, I remember the May 1 notice having two boxes on it. One was checked, one was not. The one that was checked was for a medical diagnosis. The one that was not was for functional limitations. Is that significant?
Well, so the way I read that, Your Honor, is that when the division initially looked at this file, they didn't see anything, right? The diagnosis of autism didn't come until much later. It was on August 15th of 2017, after the initial appeal had been denied. So I think the division just checked the first box that was applicable, which was the lack of diagnosis. So that's one of the problems that we're dealing with here is the first notice of redetermination comes on May 1st, and Aubrey only has 30 days to come up with testing to satisfy these requirements.
So she does.
Well-
Sorry, go ahead.
No,
So
go ahead.
she does come up with within the 30 days within the autism diagnosis. So then, but there's not a notification saying, all right, now that you have this diagnosis, we also need to establish the functional limitations.
That's correct, and quite frankly, I think it's just happenstance that she came up with the autism diagnosis when she did, because she was already involved in a process of getting more testing because she wanted to know what was going on with her daughter. It wasn't that she was getting these tests prepared to address the division's notice of termination, right? So, and that's part of the problem here.
One way to look at this is there's a notice of intention to terminate come May 1, 2017 that lists as its sole deficiency based on the review of records that we don't quite know what they are or aren't. You need a diagnosis of one of these 4 medical maladies. Mother gets that diagnosis, yet services are still terminated.
I think that's exactly right. And if the way I think you have to read this regulation, this framework, to address the issue that you're talking about with just checking one of the boxes and the overall notice problem is you have to look at the options that the division has when it's thinking about doing a determination or a redetermination. Either it can take the burden entirely on itself and say, I'm going to go out and I'm going to collect the evidence that I need to figure out whether this client does or does not have a developmental disability. And that could be as easy as sending them a notice that says, we're going to make a redetermination on this date. Make sure you schedule an appointment with our office to do tests X, Y, and Z before then, because that's the evidence that we're going to look at to determine whether you continue to be eligible. Now, that puts the burden entirely on the division, but that's not inconsistent with the regulatory framework, because the regulation says the division needs to make a determination. But the court doesn't even need to go that far, right? Because there's a second, much easier alternative, which is before the division is going to make a determination, just send a timely notice to the client that says, look, we are going to do a redetermination on X date. These are the criteria we're going to look at, all of them, not just one of them. These are the types of tests that we typically consider when we're looking at these criteria. You need to get us the evidence that we need to do this analysis, to make this determination. And you know what? If the division provides that sort of notice, then the burden shifts to the client, right? Because the client will have been involved in this process and will have provided the evidence that the division says it needs. And if the division interprets that against the client, then it's up to the client at that point to prove that the division's assessment is wrong.
Is that true, where the department is the one that's moving affirmatively to terminate services? Wouldn't the burden of going forward and marshaling that evidence to satisfy the criteria be entirely on the department?
Well, I think this is somewhat akin to a summary judgment standard in civil litigation where you're talking about initial burdens of production. Ultimately, it's our position that absolutely the division bears the burden through the hearing because, at least in this case, you have a client who was already receiving services. So the division is changing the status quo. They are taking the benefits away. They ultimately bear the burden of proof. But they can initially say, look, these are the documents we need. And if the client participates in that process and the division makes an assessment on the evidence that the client provided, then it's not unreasonable to at least put the initial burden of explaining what's wrong with the division's assessment on the client. But if you look at the flip side of this coin, where the division doesn't actually provide this predetermination notice, then sending a 30-day notice of termination is completely meaningless to the client. The client has no idea what's going on, right? Just like here, Aubrey gets this notice for the first time telling her that her services are going to be redetermined, not knowing at all what that redetermination is going to be about. And that just can't be the type of system that the legislature envisioned. Quickly, before I sit down, I think there are a couple of facts in this case that really put into stark contrast why this notice issue is so important. In our opening brief, we talked about the distinction at 6 years old, right? There's a different treatment when the client turns 6, and that was the division's alleged basis for making this decision. When the division sent its 30-day notice on May 1st, 2017, Aubrey was 7 years and 4 months old. That means 16 months had passed from the alleged triggering event and the date that the division finally decides that it's going to reevaluate her file. Even if Aubrey's mom knew what tests were required and what criteria were going to be evaluated, is it really reasonable to require her to constantly re-up that file with new tests so that there's timely information about the status of her diagnosis and the status of her condition, not knowing when the division is finally going to reevaluate her status? That just can't be a reasonable way to interpret these regulations. Reserve the rest of my time for rebuttal unless the court has a specific question.
Oh, thank you, counsel.
Excuse me. May it please the court. My name is Joanne Falgood, and I'm representing the Division of Developmental Disabilities in this case. And I think that there has been actually a couple of fundamental misconceptions in this case. The question about notice sort of presupposes that there is some particular event, notice or lack of it, that would allow or preclude a particular individual from getting services, and that is just not the case. At any point in the process, the client can submit the required documents that demonstrate both a statutory eligible disability diagnosed and the required substantial limitations on the 3 major life areas, and they're entitled to services. That's all they have to do. It's not a matter of, oh, we gave you this notice and you didn't provide the information by this date and therefore you are forever foreclosed from getting services. No, all they have to do is provide that information at any time. In fact, she could reapply today, and if she has the required diagnosis and the required substantial life limitations, she can start getting services.
So then, just so that I understand, if a client is receiving services and ADES intends to terminate those services, are you saying they're not required to provide notice?
I'm not saying that, but you just brought up the second fundamental misconception.
Okay, so answer my first question.
Okay.
Is the department required to provide notice?
The department is required to provide notice of actions that they intend to take, and I'm going to get to that procedure in just a second.
Okay, and so in that notice, the department advised the client, AW, or Aubrey, that she needed to demonstrate that there was one of a number of diagnoses, correct?
Okay, so that's the fundamental misconception right here. So may I please just allow me a little leeway?
Can you just answer my question? Do they have, is that notice that's required?
Okay.
To advise that they must establish one of several diagnoses?
Yes, they would be required to give the client notice that they need to have that diagnosis and that they need those functional limitations, and that took place.
Okay, well,
Okay,
but not at the same time.
May I clear up what I think is
No, I'll give you an opportunity to present it in the order you want to, but I just want to get to these questions in the order that I'm thinking about them, if that's okay.
I do understand. It's just that I can't really accurately answer your question. The May 1st notice is not the notice that you're thinking needs to provide all of the information
Okay,
in
so,
one packet.
but there is one notice that tells her that she needs to demonstrate that she has a diagnosis.
Right.
And that does not speak to the substantial limitations.
Right, and that is...
And that comes later, or came later in this case, at a hearing. Is that so?
That did happen later, not at the hearing, before the hearing.
Before, okay, when did it happen before the hearing?
Okay, so here's what happens. The department sends out its notice of intended action. That is not their notice that we're definitely going to terminate your benefits. That is their notice saying, hey, we're reevaluating. That's the notice that he's talking about according to the regs that needs to be given in order to even consider eligibility.
Counsel, did that notice, the May 1 notice, say we're reevaluating, or did it say, hey, we've looked at some documents, we're going to terminate next?
So, and again, this goes to the statutory bifurcation. We have, she's eligible up.
And please, I'm just talking about that May 1 notice.
Okay, so the May 1 notice, again, you just pull it up. It's this one right here, and it's Exhibit D3. And it says that they're going to terminate eligibility and they give an effective date. Now, he says that that's a year and 4 months after. I'm not entirely clear from the record, but my understanding is children ages 0 to 6, which would be up until they turn 7, would be eligible for the services.
Is that how your client construes that?
That is my understanding of it right now, but I will not, that's not this case. I didn't look at that closely. I don't know for sure, but that is
Put up on your argument.
my understanding of how that works is ages 0 to 6. She's still 6 until she turns 7. Okay, so a 4-month delay is frankly not unusual in the government context. So she gets a notice, and that would be that initial, hey, guess what, your eligibility has ended under the 0 to 6 thing, and now we need to look at whether you are eligible as an individual, and it says it checks the box for individuals 6 or older, right? So we're terminating your prior
Does that
at
answer
risk.
your question, though, in terms of what 6 means or not?
I don't have anything to cite for that.
I read the reg as saying 6 or older, not 7
Okay.
or older. That's why.
All right. Well, it may have been a little more of a delay than I'm understanding. So, but regardless, there may have been a delay. But the point is that this notice of intended action, is not a final notice. It's not saying we're definitely terminating your services in 30 days. It's saying, hey, guess what? We figured out that you are now in that 6 and older category. So when you're under 6, you can either have a diagnosis and the resulting life limitations, or you can be considered at risk. Once you're over 6, then you have to have that first thing, that diagnosis and the resulting limitations on your life functions. So this is that sort of preliminary notice, hey, your services are ending under the under 6 category. Now we need to prove the over 6. You don't even have a diagnosis on file that would begin to justify it, and that's why they didn't check the second box, because it's sort of a threshold issue to whether you have substantial functional limitations in 3 areas that result from a DDD qualifying diagnosis would be whether you have the qualifying diagnosis to begin with, and she didn't even have that.
So don't you think, though, that according to the regulatory scheme, it would be expected that when the department gives notice, hey, you're no longer within the 0 to 6, you're applying for a different category, if we want to look at it that way, that you say you must establish that you have one of these diagnoses and that you have these other, just give them everything, not you must establish that you have one of these diagnoses, sort of. I mean, I don't know why you wouldn't tell them that they need to establish more beyond that, except maybe if you assume that they're not going to be able to establish the first, then they probably don't even need to hear about all the others. If you assume that, not that the department could assume it because you have a child I mean, this doesn't appear to be a case that's sort of borderline. I mean, from reading the opening brief, at 8 years of age, this child's still being potty trained. So this is not,
Okay.
this is a serious case, apparently, of need. So, why would you just say, give us the diagnosis and not let them know that they need the other?
Well, again, it's sort of a threshold issue, and this is merely the preliminary, hey, we need to evaluate. If they can't even provide a diagnosis, we certainly don't need to weed into the thicket of whether there are substantial life limitations, because the point is, under the statute, you have to have one of those 4 diagnoses before we even consider those, because you can have substantial life limitations resulting from other diagnoses. If you read the transcript with Dr. Gray,
Right.
she talks about, ADHD can be substantially limiting. The medical things can be substantially limiting. In fact, she attributed a good portion of the developmental delays in this case to the medical issues that had gone on. The child had been hospitalized frequently, didn't have the social interactions that she might have had at school had she not had those medical issues. And indeed, that could have affected things like the potty training. The ADHD can be affecting the potty training. There are a host of other things that can be causing her issues. And the mother actually admitted in the transcript that she had made substantial gains. So,
Counsel, your point is based on the thought that the functional limitations have to trail from the diagnosis?
That is correct.
And what's the best provision that you have supporting that standard?
Okay, so...
And let me tell you why I asked that question, because I read the reg AAC R6-6-304H, and it doesn't have that link.
Okay, so under ARS Section 36559 for eligibility, it says a person with a developmental disability is eligible to apply for developmental disabilities program services and facilities operated by DDD if the person is an Arizona resident, and 2, is a person with a developmental disability and provides medical and psychological documentation of that disability, goes on, or is an infant and there's a potential that the infant has a developmental. That was the one she initially applied under. Okay, ARS 36-551-19 defines developmental disability, and it says that it means either one.
Counsel, I've read the statute.
Okay.
If that's where you find the authority, fair enough. I'm looking at the reg.
Okay.
And I don't read that link.
Okay, but the statute would certainly be
all I'm
critical.
working on is your agency's, your
Okay.
client's regulations,
And-
that it's put in place to implement the statute.
So which one are you specifically
H.
asking me about? Because I can look at that too. I'm sorry?
302H.
302H. Okay, so the one that was in effect in 2017. And sadly,
And I
everything.
can read it to you if you want. Have a diagnosis of cerebral palsy, it's one of the 4, and have functional limitations in 3 or more areas of major life activities, and then it lists them. That's it.
Okay, and you're reading R66-302?
H.
Okay, so I believe that you're looking at the new one that was amended in October 2018,
Okay.
but the one that was in effect at the time, it's very similar, actually. It says guidelines for determining developmental disabilities. It's from 2017. That was the one that was in effect when they sent out the notice in January or May of 2017. So it says autism, cerebral palsy, and mental retardation. Epilepsy and mental retardation are determined as follows. Basically requires licensed physicians or psychiatrists to determine it. And then it says substantial functional limitations must be determined in 3 or more areas, defined as follows, and it gives the list, and that's all it does.
Right.
So the new regulation is a different thing and is maybe not even relevant since it wasn't
Well,
in
but
effect
even
at the
under
time.
the one you just read, where's the link that says that the substantial functional limitation has to flow from the specific diagnosis? I think that was the question.
Okay, so, and that's where I'm going with the statute. So when it defines,
And counsel, if your answer is the statute, I understand. I mean, I was looking at the reg, and I asked you where you're basing that. And if you're basing it on the statute, that gives me my answer. Can I ask you, if I hear you right, the May 1 notice, whether it was required or not, whatever it could have done or not, was to give notice of saying, hey, you don't have a diagnosis, or different. We can't find a diagnosis in the review of our records, whatever those records may be, and we don't have those records, I don't think, on the record on appeal, but I'm happy to be wrong on that.
okay, so we have some records and we have the Dr. Gray's testimony about what was in the records that were, everything that was in the records that were reviewed, but we don't have a copy of everything that was in the file.
But if I hear you right, that notice said to mom, hey, you need to get a diagnosis. And if mom provides it, as opposed to saying, therefore you're eligible, given what you noticed, your client would then do another notice and say, oh, by the way, we have the diagnosis, but now we need to address functional limitations. Is that?
Possibly, or again.
No, I'm just trying to understand your argument.
That could be one way it goes. Another way it goes is could be maybe there was adequate evidence in the file. If they got the diagnosis, they could look at that and say, yes, it matches. In this case, when they got the diagnosis, then it went to that.
I understand what happened in this case, and what I'm trying to understand is what the purpose of that notice was, which has two boxes, one checked, one not, if it wasn't to sort of deal with everything as opposed to, if I hear you right, well, we have this first thing, and if you show that, then you got to go to the second thing, and you need to show that, and we're going to notice that, and time goes by.
Sure. And on the other hand, the alternative would be to say, hey, we need all of this stuff, and maybe the person comes back with a bunch of information about substantial limitation for major life functions, doesn't necessarily relate it to a diagnosis, and they've taken a lot of time doing that too. So, yes,
No,
could they have checked both
looking at it
boxes?
from the recipient of the notice is they're concerned about benefits and what they have to show, or what somebody has to show, and because I'm sort of assuming a burden of proof, but what somebody has to show eligibility for benefits. And if I hear you right, your client's position is, well, we can kind of do this in several steps.
And they continue to receive services while they're doing this in several steps. So, yes, there's no harm to the client at that point. She receives services while this is all pending. And so to say, hey, do you have a diagnosis, yes or no? And then she comes back with one. They go, okay, great. Now we need, and then they send that second notice, the administrative decision. They get the diagnosis.
What's that second notice? Because I don't see anything that looks like that May 1 notice.
Okay, so it's a whole different thing. So the next thing that happens, they send her the initial notice of intended action. That's the one that sort of says, and
That's the May 1 notice, is that?
No, it's not the main notice.
Okay.
I'm getting there. So I'm not sure exactly what prompted this, whether they said to her, hey, your child is over the age, you're not eligible, and she said, oh, can I please continue eligibility? And they sent this as sort of a, we've received your request, and here's our, intended response. And then she gets an opportunity to provide the information they've requested. And
Why don't you just mention, what document is that? What's the date on that?
okay, so I don't know whether there's anything written prior to this or whether it was oral that she said, hey, I'd like to continue receiving services for my over 6-year-old. The May 1st notice is the one that
Is
sort
that
of.
what you just mentioned, though? Is that part of our record or not?
Yes, the May 1st, 2017.
I understand, ma'am, the May 1st. What I heard you say, if I heard you right, and I want to understand, is that there was some communication before the May 1 here.
And that's based on what's in the transcript, where Dr. Gray says that they have support coordinators that keep the parents apprised of what they need to do next. And so, for example, it's very clear in there that when the child is about to turn 18, the support coordinator will say to them, hey, your child's about to be 18, here's what you need to do if you think you need. But she also said that will happen at the age 6 transition as well.
But there's nothing in the record
There's
to
no-
document by way of case notes, these counselors or contact people. There's nothing in there to document that. This is simply a supposition that, look, if things happen the way they're supposed to or they regularly happen, then it must have happened, but we have no real proof of that.
Okay, yeah, you're right. There's no document in the record, but they also don't require any kind of written document. So the fact
And I
that there's.
understand, but my question was, how do we know that happened? Not, was it like May 1, 2017? I think Judge Winthrop is conveying to you that we don't know.
I understand, and I'm not asking you to assume that happened. What I was trying to say is either that happened, or perhaps DVD, in its own review of the records, said, oh, wow, this child is over 7. Mom hasn't submitted any kind of request, but we're guessing she wants to continue to receive services, so we'll treat it as if she has. And instead of simply just discontinuing them because the child is not under 6 anymore, or under 7, or under 6, or whatever that cutoff is, we're going to go ahead and send her a notice that we need that diagnosis. If she provides that diagnosis, and she did, then they review all the evidence that they had in the record, and that's
Question. So when she receives the May 1 notice that says we are giving you notice that we're looking at your file and we may terminate services, and it is captioned a notice of termination, isn't it?
Notice of intended action, denial of eligibility, service system discharge. So
Okay,
what that
so
means...
just a moment. So when she gets that notice that only says you need to provide one of the diagnoses, and she provides that, and now she still has to provide additional information, what's the timing of, is there a hearing set already?
No. So she provides this Gilbert Public Schools cognitive evaluation as additional information to try to prove the cognitive intellectual disability, one of the four. She had not yet gone to the autism. And that's when then they look at the file and all the therapy notes and everything else that's in there, and they look at this diagnosis and they look at what it says and whether it says there's anything about substantial life limitations. And Dr. Gray in her testimony went through how they've got all these standard scores. You have to be 2 standard deviations or more below on these things in order to qualify as a substantial life limitation, and this didn't meet that. And
So tell me again, and you may have said it and I missed it. When's the first time that she's told you're not meeting the substantial life limitations?
Right. So
No, when?
when June 22nd, 2017, Exhibit D4 is the official administrative decision. That's the notice. That's the one that says, hey, we've taken the information you provided us and we have reviewed everything and we have determined, and this one goes through in great detail. A, you don't have a qualifying diagnosis because this document that she provided from the school district was inadequate, and B, even if we assume that it was qualifying, you don't meet the major life limitations portion. And it goes through.
Tell me again, June what?
June 22nd, 2017.
Okay. And when was the hearing?
Let me get my timeline of events here. After that, she submitted in August Dr. O'Malley's report about the autism, and the hearing was in January 2018. So she had a good 6 months after that notice to provide all of the information that was required in order to to prove that she was eligible under the new set of rules for children who are over 6. So in other words, she had that notice, and she had 6 months. And not only that, but had she asked for continuance or anything, had she called and said, what documents do you need, they would have told her. In fact, at the hearing, Dr. Gray told her, and literally spelled it out for her on the record, get the Wechsler Intelligence and spelled it for her. Get the Stanford Binet, that's Stanford like the school, B-I-N-E-T, Binet. Get that intelligence test and get these things so that we can provide you services. And had she gone out and done that, even 3 days later, and provided that information and it met the standards, she would have been eligible to continue to receive services.
So then that now brings us full circle to the question of whose job it was to, whose burden it was. Was it the department's burden to prove that she no longer qualified, or was it the client's burden to prove that she does qualify according to your position for this new category of over 6?
The second thing you said, and I'm out of time, and I would be happy to elaborate, but I'm out of time.
Thank you.
Thank you.
I'd like to quickly just clear up a few points. One is related to the age cutoff. The statute says refers to a child under 6 years of age, so it's not a 7-year-old child. So they're not cut off until their 7th birthday. It's when they turn 6. You talked a lot about counsel for the division about the May 1st notice, and she's characterized this notice as the preliminary notice that I suggested was required under the statute. I don't think there's any fair way to read this as a preliminary notice. First of all, if Ms. Washburn didn't appeal the decision, this would have become final. It says termination is effective as of this date. So that's one problem. The second problem is all this identifies is what the division says is not in the file. It doesn't say, this is what you need to come forward with. Here is your time frame for doing it, as I suggested would be required under the statute. This was the division saying, we are terminating your benefits. And certainly there's an administrative review process that Ms. Washburn took advantage of, but I don't think you can reasonably characterize this as just we're thinking about taking this action in the future.
So why wouldn't your client obtain information regarding the substantial life limitation after the June 22nd, 2017 notice?
Well, I think she tried one, and she went and obtained. She obtained the report that I believe was already in process from the psychologist. But it's my understanding, and I think this is in the transcript, that scheduling takes a long time for these types of tests, and she wasn't able to come up with that type of information before the hearing, and certainly not before the division issued what is now called the final decision at Exhibit D4. That was issued, so it was on, I think, June 22nd. So that was issued a month and a half, plus or minus a few days, after the initial notice of determination. That certainly wasn't enough time for Ms. Washburn to come up with the appropriate documents. And we know that because the only thing she could provide at that time was the analysis that Gilbert Public Schools did back in 2016.
So why
That's the
didn't
only
she
thing
ask for
she
more
could get her
time?
hands on. I'm not sure she understood that she could get more time, quite frankly. I mean, I don't think that the court can presuppose that the division would have offered an extension had Ms. Washburn requested it, particularly when the division is telling her, at least at the outset, you have 30 days, or your termination is going to become effective in 30 days. And then it sets forth the appeal rights in the final determination, but it doesn't say, oh, by the way, if you want an extension to go get all of these documents that we think you'll need, go ahead and ask for it. That's just not laid out, so I don't think it's appropriate to assume that extension would have been given. So we get back to, like you said, we now come full circle to the question of who bears the ultimate burden at the hearing. And the division didn't really rebut this point in the briefing. They only say, well, she's reapplying for benefits, so as a new applicant, she bears the burden of proof. This was not a reapplication process, and in fact, counsel acknowledged that in the administrative hearing, the division's expert repeatedly suggested that Aubrey reapply, which necessarily implies that she was not in the process of a reapplication. The division treated this as a termination of benefits for an existing recipient. It did not treat it as a hard and fast termination when she turned 6, which it could have done, right? Under the statutory language, it could have gone that route, but it didn't. It continued providing services. It said she was no longer eligible. It therefore bore the burden at the administrative hearing. Thank you.
Thank you, counsel. We appreciate the arguments presented here this morning, and we will take this under advisement and issue a written decision in due course. We're going to take a short recess to allow counsel for the next matter to come forward and get set up. Thank you.